Hello friends, myself is Mayank Kishore. Today I am going to discuss most important MCQ related to law of torts. So without wasting your time, let's start. Tort, which is derived from the Latin word tortum, is option A French word, option B a Spanish word, option C an English word, and option D a German word. And the correct answer is it is a French word, option A. Question number 2. The maxim res ipsa loquitur is option A rule of law, option B rule of procedure, option C rule of evidence, option D rule of negligence, and the correct answer is option C rule of evidence. Next question, question number 3. In tort, mistake of law is a defense, option A, option B of fact is a defense, option C is no defense, option D of law and fact both are defense, and the correct answer is option C. In tort, mistake is no defense. Question number 4. The principle Ubi Jus Ibi Remedium was recognized first time in which case it was first time recognized, and the answer is option A, that is Ashby versus White. Next question is question number 5. Gloucester Grammar School case explains. Option A injuria sine damnum, option B respondent superior, option C remoteness of damage, option D damnum sine injuria, and the correct answer is option D damnum sine injuria. Next question is question number 6. Padmavati versus Dugganaika case is related to. Option A is act of God, option B is voluntarily not fit injuria, option C private defense, option D mistake, and the correct answer is option B voluntary non fit injuria. Next question is question number 7. Tort has been defined under. So options are option A Limitations Act 1963, option B General Clause Act 1897, option C Law of Torts, and option D all of them, and the correct answer is option A Limitation Act 1963. Next question, question number 8. The name Doctrine of Pigeonhole was given by. Option A Sir John Salmond, option B Dr. Winfield, option C Justice Holt, and option D Lord Akin, and the correct answer is option A Sir John Salmond. Next question is question number 9. Acton versus Blandwell is a famous case on. Option A injuria sine damnum, option B damnum sine injuria, option C Ubi Jus Ibi Remedium, option D voluntary non fit injuria, and the correct answer is option B damnum sine injuria. Next question, question number 10. A enters a railway compartment without ticket. A T.T.E. B enters the compartment. He demands ticket from A. A cannot produce it. B, instead of taking legal action, pushes A out of the compartment and he hurt. B commits. Then option A is malfeasance, option B misfeasance, option C nonfeasance, and option D negligence, and correct answer is option B misfeasance. Question number 11. The decision in Municipal Corporation Board of Agra versus Asharlal was delivered by, and the correct answer is option D Allahabad High Court. Next question, question number 12. Nichols versus Marshland is a leading case on. Option A act of God, option B inevitable accident, option C private defense, and option D mistake, and the correct answer is option A act of God. Next question, question number 13. Negligence is a faulty mental condition which is penalized by award of damages held by. Option A Salmond, option B Savni, option C Austin, and option D Winfield, and the correct answer is option C Austin. Next question, question number 14. Nuisance as a tort was defined as unlawful interference with a person's use of enjoyment of land or some right over or in connection with it held by option A Salmond, option B Pollock, option C Winfield, and option D Underhill. And the correct answer is option C Winfield. Next question, question number 15. The maxim Q facit per alium facit per se. What is the meaning of it? Option A, he who does an act through another is deemed in law to do it himself. Option B, he who does an act through another is not deemed in law to do it. Option C, vicarious liability. And option D, both A and C are correct. And the correct answer is option D, that is both A and C are correct. Next question, question number 16. One of the remedies for false imprisonment is, and the options are option A mandamus, option B habeas corpus, option C quo warranto, and option D certiorari. And the correct answer is option B habeas corpus. Next question, question number 17. A person may be falsely imprisoned while he is options A asleep, option B drunk, option C unconscious, option D all of the above. And the correct answer is D all of the above. A person may be falsely imprisoned while he is asleep, drunk, or unconscious. Question number 18. Pointing a loaded pistol at another is option A assault, option B battery, option C both A and B, and option D wrongful restraint. And the correct answer is option A assault. Next question, question number 19. Trespass to good include option A detainee, option B conversion, option C both A and B, and option D none of the above. And the correct answer is option C both A and B. Trespass to good includes detainee and conversion, both. Next question, question number 20. Which of the following is stock are considered trespass to person? Option A assault, option B battery, option C false imprisonment, and option D all of the above. And the correct answer is option D all of the above. That means assault, battery, and false imprisonment, these all are the trespass to the person. Next question, question number 21. A, an employee of a bank was arrested by police upon a written complaint of the bank. A was acquitted at session trial. A claimed damages. Option A, as bank caused arrest of A, hence it is liable. Option B, bank had a probable cause, hence no false imprisonment. Option C, bank had a reasonable cause, hence no false imprisonment. And option D, none of the above. And the correct answer is A, as bank caused arrest of A, hence it is liable. Next question, question number 22. The dictation of letter to a typist is option A is slander, option B libel, option C defamation, and option D both A and B. And the correct answer is option A slander. Next question, question number 23. The rule of strict liability was laid down in Renal versus Fletcher, most important case. Renal versus Fletcher by option A Blackburn Justice in 1868, Lord Akin in 1635, Blackburn Justice in 1865, and Holt Chief Justice in 1865. And the correct answer is option A Blackburn in 1868. Next question, question number 24. The rule of absolute liability implies option A strict liability, option B stricter than strict liability, option C state liability, option D vicarious liability. And the correct answer is stricter than strict liability. Question number 25. Bhopal gas leak disaster was a result of leakage of which type of gas? And the options are option A methyl salicylate, option B methyl acetate, option C methyl isocyanate, option D methyl carbonate. and the correct answer is methyl isocyanate. And the correct answer is option C, methyl isocyanate. Next question, question number 26. When two persons coming from opposite direction in their cars collided with each other, in that process, a person who was standing on the roadside gets injured, then the two motorists are option A, two negligent person, option B, participant in contributory negligence, option C, joint tortfeasors, and option D, independent tortfeasor. And the correct answer is option D, independent tortfeasors. Question number 27. In law of torts, the remedies available are option A, executive and non-judicial, option B, judicial and extrajudicial, option C, judicial, non-judicial and extrajudicial, and option D, executive and judicial. And the correct answer is option B, judicial and extrajudicial. Question number 28. Which of the following is an extrajudicial remedy? Option A, expulsion of a trespasser. Option B, re-entry on land. Option C, distressed damaged pheasant. And option D, all of the above. And the correct answer is all of the above. Next question, question number 29. Charge of tort implies option A, the judgment has not been pronounced. Option B, that no relief has been given. Option C, no action lies after the death of the parties. Option D, that no records has been arrived. And the correct answer is option C, no action lies after the death of the parties. Next question, question number 30. In which of the following cases it was held that no exemption clause in a contract is capable of exempting a party from tortious liability? And the options are option A, Dongi versus Stevenson, option B, Grant versus Australian Knitting Mills, option C, Ashley versus White, and option D, White versus John Rick and Company. And the correct answer is option D, White versus John Rick and Company. Next question, question number 31. The maxim alteram non lidere means option A, to hurt nobody by word or deed. Option B, a legally authorized act resulting in injury. Option C, where there is a right, there is a remedy. And option D, a violation of legal right. And the correct answer is option A, to hurt nobody by word or deed. That means next question, question number 33. The case Ashley versus White recognized the principle of Ubi Jus Ibi Remedium. It followed which of the following theories? Option A, Winfield theory, option B, Salmon's theory, option C, Savigny's theory, and option D, none of the above. And the correct answer is the case Ashley versus White recognized the principle of Ubi Jus Ibi Remedium related to Winfield's theory. Next question, question number 34. A mere verbal threat or a threat of gesture is option A, assault, option B, battery, option C, threats, option D, none of the above. And the correct answer is it is none of the above. Next question, question number 35. A man of power orders B to stand in the scorching sun. B, out of fear and in obedience to the order of A, keeps standing in the sun. Then A, option A, this is false imprisonment, option B, this is battery, option C, this is assault, and option D, both A and C. And the correct answer is this is false imprisonment. Next question, question number 36. Negligence is culpable carelessness. This viewpoint was expressed by option A, Pollock, option B, Salmon, option C, Halsbury, option D, Winfield. And the correct answer is option B, Salmon. Next question, question number 37. In which of the following case it was observed by Lord Akin that the rule that you are to love your neighbor becomes in law, you must not injure your neighbor? And the options are option A, Haven versus Pender, option B, Grant versus Australian Knitting Mills, Option C, Dongue versus Stevenson, and option D, Glasgow Corporation versus Muir. And the correct answer is option C, Dongue versus Stevenson. Question number 38. After the event, even a fool is wise, but it is not the hindsight of a fool. It is the foresight of a reasonable man which alone can determine responsibility. A statement was given in which case? Option A, Re Polemis case. Option B, Hughes versus Lord Advocate case. Option C, G versus Metropolitan Railway. Option D, Bag and Mount case. And the correct answer is option D, Bag and Mount case. Next question, question number 39. Knowledge of the restraint to the person falsely imprisoned id. Option A, essential. Option B, it depends on the nature of the case. Option C, not essential. Option D, none. And the correct answer is option C, not essential. Knowledge is not essential for the person who falsely imprisoned. Next question number 40. In contributory negligence, A, both parties have contributed to negligence equally. B, only one party is negligent and other has not taken due care. Option C, one party is negligent resulting in injury while the other has taken due care. Option D, when lack of care is equal on both sides. And the correct answer is option B, only one party is negligent and other has not taken due care. Next question number 41. Which of the following is not a libel? Option A, defamatory matter in writing or printing. Option B, signs or picture. Option C, talking cinematograph film. Option D, sound or gestures. And the correct answer is option D, sound or gesture is not a libel. Next question number 42. Vidyavati versus State of Rajasthan is a case law related to. It's a very famous case, and options are option A, tortious liability of a corporation. Option B, tortious liability of a company. Option C, vicarious liability of a state. And option D, none of the above. And the correct answer is option C, vicarious liability of a state. Next question, very interesting question, question number 43. Which of the following is a correct definition of trespass to land? And here option A is interference with the ownership of land without lawful justification. Option B, interference with the possession of the land without lawful justification. Option C, interference with the occupier of land without lawful justification. And option D, all of the above. And यहाँ पे शब्दों का खेल है, ओनरशिप, पोजेशन एंड ऑक्युपायर. And the correct answer is option B, interference with the possession of the land without lawful justification. Next question is question number 44. When an agent commits a tort in performance of his duty as an agent, the injured party can option A, sue the principal only. Option B, sue the agent only. Option C, sue either the principal or agent or both of them. Option D, not sue the principal or the agent. And correct answer is option C, sue either the principal or agent or both of them. Next question number 45. The expression constitutional tort means, very important question, ये कभी कभी इंटरव्यू में भी पूछा जाता है. ऑप्शन ए tort that injured many people. Option B, an act constituting a tort. Option C, a tort permitted by the constitution for the benefit of a large number of people, although it violates the right of few. Option D, a violation of one constitutional right by a government officer and action. And the correct answer is option D, a violation of one constitutional rights by a government officer or action. Next question number 46. Last opportunity rule is related to, and the options are 1 A, nuisance, B, negligence, C, remoteness of damage, and D, trespass. And the correct answer is option B, negligence. Next question is question number 47. The term vicarious liability was coined by option A, Pollock. Option B, Winfield. Option C, Savini. Option D, Pound. and the correct answer is option A, Pollock. Next question, question number 48. In which of the following case it is not nuisance? Option A, playing music through loudspeaker in the night. Option B, creation of foul smell on one's land which reaches neighbors. Option C, taking cattle on the field of another. Option D, construction of a flour mill on the ground floor while the first floor is occupied by a tenant. And the correct answer is option C, taking cattle on the field of another. It is not a nuisance. Next question, question number 49. Which of the following sets of defense available in an action of defamation? Option A, truth, privilege, mistake. Option B, privilege, mistake, fair comment. Option C, privilege, truth, fair comment. Option D, truth, mistake, fair comment. It's a very important question. And the correct answer is option C, privilege, truth, fair comment. These all are set of defense available in an action for defamation. And the last question is question number 50. The plaintiff, a lady, visits a restaurant, was injured by ceiling fan which fell on her. The reason for falling of the fan was latent a defect in the metal of the rod of the fan. In an action against the defendant, he is option A, liable because of last opportunity rule. Option B, not liable because injury was not foreseeable. Option C, liable because the injury was foreseeable. And option D, liable because of doctrine of res ipsa loquitur. And the correct answer is ऑप्शन बी, नॉट लायबल बिकॉज इंजरी वाज नॉट फॉरसीएबल। तो हमने फटाफट 50 क्वेश्चंस किए लॉ ऑफ टॉर्ट्स के, ये फर्स्ट पार्ट था। एंड फॉर नेक्स्ट पार्ट प्लीज लाइक शेयर एंड सब्सक्राइब माय चैनल। थैंक यू वेरी मच।